Just a drop, just a drop, just a drop is all you need. Just a drop, just a drop.
Hello, hello. Welcome to another Raindrop broadcast where just a drop is all you need. I am your host and founder, Dr. Angela D. Stanley, and we're coming at you today to help you mind your entertainment business, some successful tips for the trade. And so we're excited because we have an exclusive interview. We were able to be on location at the Brennan Legal Group in Orlando, Florida with attorney Terry Brennan, and he made us privy to some wonderful information to help us in the entertainment arena and give us some legal advice, I'll say. So anyway, you don't want to miss this. You're going to really be moved by this one. Sit back, relax, and enjoy.
Just a drop, just a drop, just a drop is all you need.
I'm here with Terry Brennan of Brennan Legal Group, and I would like to just sit here and find out if you could tell us a little bit about your company and what you do. Sure. And what do you specialize in, please?
I am a business and intellectual property and entertainment transactions lawyer, and what that means is, in general, I advise businesses in all forms of activity ranging from startup and financing and protection of intellectual property and licensing, and in the entertainment area that typically involves the creation of a business for either an entertainer or a startup company, the protection of their content or talent in the sense of licensing agreements and distribution agreements and author agreements and screenwriter agreements and things of that type. And it varies depending upon the particular area of entertainment or digital media that we're talking with. A video game company is going to be far more concerned with with simpler aspects, things such as software licensing and development agreements and distribution agreements, whereas a record production company is going to be concerned with the acquisition of content, rights waivers, distribution agreements, financing, arranging tours, promotions, that type of thing. So, but basically I'm a business lawyer and I do all of those types of things.
Well, we are in the right place with you. The question, you have so much that you do and so much that you specialize in. How long, if I may ask, how long have you been in the legal business?
I started practicing in New York in 1980, a long time.
Wow, that is. Now, you mentioned the different things about intellectual properties that you work with. So for the listeners, how important is it for entertainers or those in the entertainment industry to protect their intellectual property or to do what it takes to make sure that they're protected and covered?
Well, if you don't protect your intellectual property, you have no asset. You have nothing to offer. Okay. If you don't, I mean, typically in a standard entertainment transaction, the talent, that is the author, the singer, the actor, is not personally going to actually own the intellectual property. They're going to be paid for performing whatever it is that they do, but the actual intellectual property rights are going to be assigned to the company, whether it's a television production company, whether it's a record production company, or similar type of organization. But for an artist who is in an earlier stage of her career, you need to be very careful about, if you write a song, you should think seriously about filing a copyright registration. If you have a marketing campaign, you should think seriously about registering the trademark to protect it. But to the extent that you provide your artistic work, whether, let's stick with a song, to the extent that you put that on the internet or put it in public domain, you're going to affect your ability to restrict others from doing the types of things that the copyright law allows you to do. Okay, the copyright law, again, sticking with music, gives you the right, exclusive right to make copies of a song, to distribute it, to prepare what we call derivative works of it.
Okay.
And if you allow your work to go into, you put it up on Yahoo or Facebook, and you don't put any restrictions around it, you let everybody access it and copy it and play it as they want, you are not going to be in a strong legal position to prevent somebody who you really don't want to be distributing it from doing so. You will have waived those rights. Okay?
You know, you answered probably the next 3 questions that I had. That was
ask them anyway.
Thank you so much. I was actually, and you really touched on it when you said, because I'm a songwriter and I know several songwriters, so I was going to ask you how important it is for copywriting, and you began to express that, and you made the comment about, I love when you said that about the derivative works, and you talked about posting, because you know they post everything now on Facebook, Twitter, you name it, but if somebody else finds that work and a song, say I've written a song, haven't copywritten or anything, and so they find that and they decide that they're going to use it and get plenty of money from it. So you mean that the songwriter doesn't have any kind of legal stance, or how does that work?
No, let me, I think I was probably moving too fast. Let's go back to some basics.
Okay. What's the basics?
Let's use the song as an example. Okay. You don't have to register a copyright to have rights under the Copyright Act. So if you write a song, in fact, if you take notes on the document that's in front of you, you have a copyright in that. In the note sheet that you have there, you have a copyright on it. Whether it's something that anyone's going to want to buy is a different issue. So, and the fact that you put let's say that you record your song and you put the song up on MySpace or wherever it is that you're putting it, you're not in itself, by doing that, waiving copyright rights. But if you don't put it up there with some restriction, if you don't, if someone else if you put a recording on Facebook or MySpace or whatever it is that you're putting it on, obviously you're putting it there for other people to listen to, because that's the point.
Exactly.
But if the folks who are downloading your song then get into the business of using it themselves, or distributing it, or copying it and selling it, that violates one of your monopoly rights under the Copyright Act. Okay, so when I say you need to protect it, it doesn't mean that you lose anything by taking advantage of social media or other sites. What you need to do is to watch what happens with it after that point in time. And if you become aware that somebody has, as they say, infringed your rights, you need to take some action to protect that. Now, you can't, unless you register your copyright, you can't take advantage of the most powerful way of enforcing your rights, and that is to file a lawsuit. Because you can't file a lawsuit under the Copyright Act unless you have a registered copyright. Registering copyrights is not an expensive thing to do. Some people can do it on their own, others choose lawyers to do it. So that's what I mean when I say the Copyright Act gives you, as does the Trademark Act, a whole series of rights. And you have to sort of police those rights.
Wonderful. Well, you explained that very well. Thank you very much. And you mentioned the trademarks and the patents. What would be the difference between the trademarks and the patents here?
Well, they're two completely different areas. So a trademark, simply stated, a trademark serves is a word or a collection of words or a symbol that that the purpose of which is to identify the source of a product or a service. Okay, so trademarks are Facebook, Google, Coke, Pepsi, those types of things. The purpose of those marks is to identify in the public mind a certain quality of goods and a certain a level of goods and a certain source of those goods. In this case, Coca-Cola or Pepsi or Facebook or Google. A trademark does not protect content. It doesn't. If you write a song, you don't trademark the song. The only way you can protect that content is through a copyright. A patent, on the other hand, is a far stronger monopoly, and it protects ideas. All right? The copyright law does not protect an idea. If you write a song, there is nothing that prevents someone else from writing a song with a similar verse or a similar thing. That's why we have a zillion love songs. They can't copy your exact song, and they can't copy your sound recording, but they can record something that is significantly that may be similar to it, as long as they don't copy what you have produced. All right, and it gets a little more complicated than that. I won't go into it. Right?
Exactly.
A patent protects an idea, and there are certain requirements in order to receive a patent. The idea has to be embodied in some form of object. The object has to be useful, like a telephone or your cell phone or the motherboards. It has to be novel. That is, it has to be new within the context of the patent law. It has not to be obvious. You can't go in and patent something just because it's new. You can't patent a top to a water bottle because it may have a useful function, but it's certainly not novel. So patents, however, give you much stronger rights. They give you the right to prevent someone from using it in almost any way, from manufacturing it, from copying it, that type of thing. Almost very few things in the entertainment law are patentable. Very few,
because a lot of people have probably already...
Because they're not, it's not sufficient subject matter for a patent, and because it's also not worth it most of the time, even if it was patentable. For example, the only thing a song is not patentable. A movie is not patentable. The special effects in a movie, the programs that generate the special effects, the programs that generate some of the sound, the post-production, those might be patentable. But the artwork itself will not be.
Well, wonderful, wonderful. The next question, what wisdom or advice would you give to an artist just starting out in the industry that's looking to maybe get a recording contract, or someone who wants to get into the business and they've been writing so many songs, doing all of this, they've been doing several shows and have so much going on? Could you give just a little advice for someone who's deciding to go into the entertainment industry?
Boy, if I could give advice that would be, which if followed would yield to success, I wouldn't be doing what I'm doing. The simple answer.
I love it. I love it.
The simple answer is try to get a good agent, but getting a good agent is a very hard thing to do.
Very hard, yes.
Particularly these days, be distributed and appear on as many sources, social media sources, as many broadcast sources as you possibly can. Because the way to get noticed is to get noticed, and I would, on a less interesting note, you really need to learn the business. You need to spend, in addition to the time that an artist spends on her art or her songs or her recording or acting or whatever, you need to understand what the business is about.
That's good.
But I don't do a lot of work anymore on the promotional side of entertainment, so I'm probably not the best person to ask for that.
Well, if I may interject, that was very good wisdom. Thank you very much. That was very good. And one other thing, we had talked, I think, a little bit earlier pertaining to nonprofits and charitable organizations. And now there's so many in which there's the nonprofit and then the entertainment is so very close together. I know that there are a lot of artists now who are starting foundations for, maybe I know one particular artist that is doing one for human trafficking. And just so much, feeding the poor. So would you give any wisdom of those that are in the entertainment industry and the nonprofit of how to make those compatible and not, break any laws, if I might say?
Well, and this sounds really dull because it is, but the primary issue in the establishment and the commercialization or the marketing, if you will, of a not-for-profit foundation is tax-driven.
Okay.
The Internal Revenue Code establishes certain very specific requirements as to the business in which a not-for-profit can be involved, the way that funds are used, the reporting requirements, the entities and the persons who can be in it, the distribution of shares or membership or interests in it. So, and the reason for that is because they obviously don't want Mick Jagger giving concert performances and then directing the revenue through a not-for-profit that then distributes it to an offshore entity that is owned by Mick Jagger.
Oh, okay? Got you.
And beyond that, it's kind of hard to address that in this discussion because the tax requirements are, on a Friday night is already bad enough to listen to a lawyer. But if you want to see it get worse, we could start talking about 501c3 requirements.
Well, that would be a whole nother interview.
But again, that's part of learning the business. Most fledgling talent, however, I think really should concentrate on the distribution and the perfection of the talent and worry about the 501c3 foundations after you get a recording contract or you get a good promotional tour or you get a good booking somewhere, because prior to that you don't have anything really.
Okay. So, well, I appreciate that. And what you've described and what you shared has been very helpful. And I'm sure that the listeners and our readers would just really receive a lot from this. And what I'm getting out of this is, bottom line is, if anybody's in the entertainment industry and desires to go for, they need to get an entertainment attorney.
It would help.
It would help. Okay. Yeah. I'll promote that myself. I know you're very humble in saying that. But I do appreciate you taking out this time for me. The last thing, it's not a question, just we're going to end this interview, but if there's any final words that you'd like to share, I just want to give you this opportunity to do that before we close out.
If you're not having fun, don't do it. When it stops being fun, don't do it.
I love that. Well, we're going to end on that. Thank you so much, Terry Brennan from Brennan Legal Group, for having me and for sharing with the interview and all of the wisdom you've learned over these many years.
God, don't say that.
Okay,
feel awful.
No, that should be great. That should be great.
In a few years.
In these few years.
That's right.
And thank you very much.
Well, thank you. You have been listening to the Raindrop podcast, where just a drop is all you need. And I am your host and founder, Dr. Angela. And thank you. I hope that this has been very helpful to you. So mind, entertainment, business, and we'll see you next time. I know it's been hard. Don't know what to do. Just trust it.